terms of issue of shares, and the advantages that would be obtained by investing in the company. Now, terms of issue means actually these are rights, right? Rights given to the shareholders or rights approved by the board of directors, approved by the board of directors, board of directors, board of directors at the time of issuing of shares, right? At the time of issuing of shares. At the time of issuing of shares. Or we can say, right, these rights are known as terms of issue. Terms of issue, rights given to the shareholders by approving the board of directors at the time of issuing of shares. Right, so what are the rights given to shareholders? Right, they are mentioned in the or set out in the document or the advertisement. And advantages, what are the advantages can be obtained if you invest in the shares of this company, right? So these are mentioned in the prospectus. Then thereafter, the second step is application. If any person is interested to invest in shares of the company, he will apply for the shares. So this is the application. Apply for the shares. That is treated as offer, right? This is treated as offer. You can say offer. So first, invitation, it is known as invitation, or prospectus is the invitation, right? You can say prospectus. Prospectus, then application, that is the offer, right? Then what happened? Allotment. Allotment is the acceptance. If the company accepts the application made by the person, then the company will allot shares to that person. Then he will become a member of the company. So actually the contract made between that person and the company. Right? His name will be entered on the register of members. Right? He is registered as a member of the company. Right? So he will be a member of the company. Member of the company. Right. So that is the contract made between these two persons, company and the this applicant. The prospectus is treated as an invitation, right? Prospectus is the invitation to treat, or invitation, you can say invitation. Application for the shares by the prospective members, right? Prospective, future members. Prospective means future, right? Future members is treated as an offer. So this is an offer, right? Application is treated as an offer. The company accepts the offer by allotment of shares to that person. So allotment means acceptance, right? Invitation, offer, acceptance. Then there will be a contract. This is the fourth step. Contract made between company and that person, right? Contract made between the company and the applicant, right? So that will happen after allotment. This procedure is only applicable for the public companies, right? As we discussed earlier, right? Private companies are not permitted to invite public to purchase shares, and the company limited by guarantee, they don't have share capital, right? They don't have share capital, right? So this is mainly applicable only for the public companies. Public companies can invite the public to purchase shares, right? And not for private companies, because private companies cannot make an invitation to public to purchase its shares, right? Uh, we have discussed actually according to the articles, these if it is a private company, according to the articles, it prohibits to invite the public to purchase the shares, right? So this procedure is only applicable for public companies, right? So that is the procedure, right? Invitation, then offer, acceptance, then contract made between two parties. So here invitation means prospectus or the paper advertisement by inviting the public to purchase shares, and application made by the prospective shareholders, right? And the company can either uh, allot the shares, so refuse to allot shares to that applicant. So allotment means acceptance, right? Then if the offer is accepted, then what happens? Valid contract form between two parties. Understood? Right. So this is the process that the public company has to adapt in order to raise its share capital. Right. Then thereafter, we'll consider about the prospectus. Right. So every prospectus shall contain, right? So here it says the information, the first one with regard to information. Information specified in the part 1 of the 4th schedule. Right? Actually, now what are the information to be mentioned in the prospectus according to the Companies Act, right? So here, part 1 of the 4th schedule, it says, right? Uh, some of above mentioned information are not all, right? Some of these informations are objects of the company. Objects of the company, name and addresses of the directors or proposed directors, minimum subscription, another important one, right? Minimum subscription, right? So these are to be mentioned in the prospectus, basically, right? Objects of the company. Now, under the topic that we have discussed, this topic is articles of association. So when we are discussing the topic articles of associations, right, we have learned the company may set out its objects, right? The company may set out its objects, right? And further, we have discussed the company may set out its objects, rights and privileges of the shareholders, right? Terms with regard to management and administration, and any provision not violating the Companies Act, right? Any provision not violating the Companies Act in its articles of association, right? So in that topic, we have mentioned here it says may set out, right? May set out objects, right? May set out its objects. right? Therefore, I told you because of the word may, setting out objects in the articles is not a compulsory requirement. It is not a compulsory requirement. We have discussed this, right? It's not a compulsory requirement. It means the company either mention its objects or uh, refrain from setting out its objects in the articles, right? Because of the word. This is may. Therefore, it is not compulsory requirement. But further, when we analyze these concepts, then I told you as far as concerned companies limited by guarantee, right? Companies Act says that company shall mention its objects in the articles. Therefore, if it is a company limited by guarantee, it shall mention its objects, right? And further, we have discussed as far as concern the public companies, right? Uh, when they have to setting out its objects in the prospectus, right? Prospectus, right? If it is a public company, then that company has to mention its objects in the prospectus. We have learned that. Then actually what happened, we have further discussed, may set out that rule is basically apply for the private companies. Private companies. Now the reason, now you can identify here. Now in the prospectus, when we consider the what are the information to be mentioned, right here it says, right, first one is objects of the company. So actually what happened, even though here it says may set out, this is section 13, right, according to section 13, right, it says may set out, that rule is, right, uh, only applicable with regard to private companies, right? Because if it is a public company, then they have to set out its objects in the prospectus. So we have discussed. Therefore, the Companies Act impliedly induce these companies, public companies, to mention their objects in prospectus, right? So they have to mention objects of the company in the prospectus, right? And name and addresses of the directors or proposed directors, right? No special reason, right? Here they have to mention the names and addresses of directors, right? And the minimum subscription, another very important one, right? Minimum subscription, right? So when we consider the minimum subscription, that is, now this is the minimum amount uh, that to be collected from the public by issuing shares to the public, right? So if this amount, minimum amount, is not collected by the company from the public, then actually this company cannot allot any share to the public. Company cannot allot shares to the public. Therefore, the minimum subscription is very important one, right? It to be collected from the public. Otherwise, the company cannot allot any share to the public, right? So, what is the minimum subscription, right? Minimum subscription means, according to the opinion of the directors, the minimum amount that must be raised or collected by the company by issuing of shares for the following purposes. Right. So there are several purposes mentioned here. This is the minimum amount to be collected by the company from the public for these purposes. That amount is known as minimum subscription, right? What are the purposes, right? The purchase price of any property, right? Purchase price of the property, any property, right? Then that amount to be collected from the public. Preliminary expenses, it to be collected from the public. And commission payable to the underwriter is another underwriter, another term. Underwriter we'll discuss later on, right? Commission, we have to pay commission to the underwriters, then that amount to be collected, and working capital, right? And payment of any money borrowed by the company in respect of aforesaid matters. It means now if the company has taken a loan for these purposes, right? So that loan, in order to settle or paid off that loan, that amount also to be collected from the public, right? All together, right? We can name it as minimum subscription. This is the minimum amount that to be collected from the public in order to allot shares to the public, right? Minimum amount, right? Then now here, uh, underwriter, commission payable to underwriter, right? Now it is very clear. Now, if company unable to collect this minimum amount from the public, then that company cannot allot any share to the public. Therefore, there is a risk, right? So we can identify there is a risk on the part of the company, right? Risk. It means the company, if the company unable to collect the minimum subscription, then company cannot allot any share to the public, right? Therefore, there is the risk. Therefore, in order to overcome this risk, company can engage into a contract with another party, right? This is the company. And the other party is known as underwriter, right? Underwriter, right? In order to avoid this risk, right? Company engage into contract with an underwriter, right? Uh, for a commission, right? As a consideration of the contract, the commission is payable to underwriter, commission to be payable, right? So this contract is known as underwriting contract, right? Underwriting contract. It's a contract made between these two parties, right? Basically, very right, very simple. That is, here under this contract, the main condition is underwriter, right, will purchase. Now, why we engage into this type of contract? In order to avoid the risk. What is the risk? If the company unable to collect the minimum amount from the public, then company cannot allot shares to the public, right? Therefore, right, this contract was made between company and the underwriter. According to the terms of the underwriting agreement or a contract, right, underwriter agrees to purchase a specific number of shares in order to meet the minimum subscription, right? If the company unable to collect it from the public. Understood. So that is the main term under this underwriting agreement. right? Now suppose the minimum amount to be collected from the public is 100. Is 100. Then company able to, so this is the minimum subscription, right? Minimum subscription is 100. Minimum amount to be collected from the public. By inviting the public, company can allot only uh, only 80 rupees, right? Company able to collect only 80 rupees from the public. Then actually this company cannot allot shares to the public. Then what happened under the underwriting agreement, underwriter, right, agrees to purchase the lesser amount to meet the minimum subscription. That is, underwriter agreed to purchase 20, right? Then what happened? So company can collect, right, 100 rupees or 100, right, from the public, and as well as the underwriter purchase 20, then minimum subscription is okay. Then company can allot shares to the public. Understood. So this is the underwriting agreement, right? So the main thing is underwriter agrees to purchase the specific number of shares in order to meet the minimum subscription of the company. If company unable to collect it from the public, right? So now here what happened? Uh, even though the underwriter will call upon to purchase the shares or not in the future, right? He is undertaking a risk. Therefore, company has to pay a commission to the underwriter. Whether he now suppose the minimum subscription is 100, then company able to collect, right, 120 from the public. Then underwriter need not to purchase any amount. That is zero, right? He need not to purchase, right? Even though he has not purchased any amount, right? Need not to purchase any amount, commission to be paid to the underwriter because he has taken, right, uh, a particular risk, right? Therefore, commission to be paid to underwriter whether he will call upon to purchase the shares or not in the future. Understood. So that is another very important term contained in the underwriting agreement. So this is known as underwriting agreement. Here it says uh, if the minimum subscription was not received by the company, then it cannot allot any share capital to the public. Therefore, in order to avoid this risk, company make an underwriting agreement, right? Underwriting agreement. Underwriting. An underwriting agreement is a contract made between company and underwriter, right? So the main condition in such a contract is that the underwriter should purchase specific number of shares to meet the minimum subscription. In the case if the company, in the case if the all the shares or an adequate number of shares were not purchased by the public. So in order to meet the minimum subscription, uh, in that case, in order to meet the minimum subscription, underwriter will purchase the shares of the company. Right. Then thereafter it says the underwriter will receive a commission as consideration. right? So that is the consideration to be paid to the underwriter under this contract or the agreement, underwriting agreement, right? Commission to be paid to the underwriter. This commission becomes payable whether the underwriter is eventually called upon to purchase shares or not. Right? That's why what I mentioned here, even though the underwriter will call upon to shares or not, we have to pay the agreed commission to the underwriter. Right? Then further it says details with regard to underwriting commission should be set out in the prospectus. So that is mentioned here, right? In the prospectus, we have to mention the commission payable to the underwriter. Here. Right here, commission payable to the underwriter. Right? It to be mentioned in the prospectus. Right? Then thereafter, further here it says now information here, these are the information to be mentioned in the prospectus. Objects, name and addresses of the prospectus, minimum subscription. Under that we have to mention the commission payable to underwriter, and thereafter further the fourth one, it says the amount payable on application and allotment on each share. Amount payable on application and allotment. With the application, how much of money to be paid, and on allotment, how much of money to be paid, that to be mentioned in the prospectus. Names and addresses of the auditors, right, to be mentioned, right, in the prospectus. So these are some of information to be set out in the prospectus according to the part 1 of 4th schedule, right? Part 1 of 4th schedule. This is part 1 of 4th schedule, right? Then in the prospectus, we have to mention reports, right? We have to mention some of reports. They are mentioned in part 2 of 4th schedule, right? The earlier one is part 1. This one is part 1 is with regard to information, right? And part 2 is with regard to reports, right? That is very simple. Auditors' reports, and what are the reports? Auditors' reports and accountants' reports, right? To be specified in the prospectus, right? That is about the prospectus, right? So we have to mention some informations, right? They are specifically mentioned under part 1 of the 4th schedule. Some of information mentioned here: objects, names and addresses of directors, minimum subscription, and amount payable on application and allotment, right? Names and addresses of the auditors, right? Then there are some reports to be mentioned, that is auditors' reports and accountants' reports. Right? So all are facts, right? Right. So that is about the prospectus. Then thereafter another heading, it says prospectus shall be dated, be signed, shall be dated, be signed, and be registered. So here actually we can identify 3 requirements. One is compulsory requirement: be dated, be signed, and be registered. Right? Dated, right? When we consider the date, right? every prospectus shall bear a date, right? This date is treated as the date of publication of such prospectus. So the date is not considered as the date of publication of this prospectus. That is known as be dated. It to be dated. Prospectus to be dated, right? It to be signed, right? It to be signed by whom? Directors and proposed directors who are named in the prospectus to be signed the prospectus. Every person who is named in the prospectus as a director or proposed director of the company shall be signed it with the declaration. Another one, very important one is declaration, statement to be given. According to the statement, right, they have to mention that they have uh, read all the provisions contained in the Companies Act with regard to issue of prospectus. Right? They have gone through all the sections mentioned in the Companies Act with regard to issue of prospectus. And further, they have to mention this prospectus, the prospectus concerned, is comply with those provisions. There is a declaration to be given by the directors and uh, prospect, right, proposed directors uh, who are named in the prospectus, right? What is the declaration? That is very important, right? They have, right, read the provisions of the Companies Act with regard to issue of prospectus, and this prospectus is comply with those prospectus provisions, right? It complies with the prospectus is complied with those provisions. So that is the declaration to be given by the directors, right? Then there's another requirement is it to be registered. Prospectus to be registered. Registered with whom? It to be registered with Register of Companies, right? It says now on or before. Now here it says every prospectus shall bear a date on or before the date. So this date is treated as the date of publication of such prospectus, right? So on or before the date that the prospectus is published, a copy of the prospectus to be sent to the registrar for the purpose of registration. That is known as prospectus to be registered, right? On or before, right? That is very important. On or before the date of publication of the prospectus, copy of such to be delivered to the Register of Companies for registration. If not, if a company or any officer who has violated this requirement, then what happened? The company or any officer, right, who authorized the publication of this prospectus without a copy is being registered with the Register of Companies, then that company as well as every person, right, shall be guilty to an offense. On conviction, be liable to pay a fine not exceeding 200,000 rupees. So that is the punishment can be given for the company as well as to the officer who issue a prospectus without uh, a copy is being registered with the Register of Companies, right? Where the prospectus is published without a copy is being delivered to the registrar, the company and each person who is knowingly being a party to issue of the prospectus shall be guilty to an offense. It is treated as a crime. On conviction, be liable to pay a fine not exceeding 200,000 rupees. So that is the punishment given for the sorry, violating the provision, right? So it to be registered with the uh, register of companies, right? So on or before the date of publication of prospectus, a copy of the prospectus to be sent to the register of companies for the purpose of registration, right? Unless the company and every officer who is knowingly uh, publish a prospectus without a copy is being registered shall be guilty to the offense. On conviction, be liable to pay a fine not exceeding 200,000 rupees. Right? So that is the requirement, right? Shall be dated, shall be signed, and shall be registered, right? Then we can move on to the next heading. It says untrue statement in a prospectus. Right now, actually, here what happened? If there is an untrue statement in the prospectus, then rely on that untrue statement. Suppose a particular person has invested money in the shares of the company, or he purchased shares of the company. Rely on that untrue statement. Then what are the remedies available to that innocent party? Right. So basically, we can identify there are two remedies available to the that party who has invested in shares rely on untrue statement, right? So when we consider the reliefs or the remedies available to that type of person, actually we can consider the remedies under two categories. One is under civil law, and another uh, by another way that party can seek a relief, that is under criminal law. But actually, when we consider the criminal law, there is no any benefit to that person who has right invested in the company. But there are some really provisions under criminal law, right? If there is an untrue statement contained in the prospectus, right? Now, only thing is now under civil law, right? That now actually the benefit is given to the investor, right? Who invest money in shares, rely on that untrue statement. Then, if that person suffers any loss, right? So under civil law, if that person suffers any loss, then he can recover it from the company, right? So it is benefited to the investor or the aggrieved party or the innocent party. He can recover loss or he can recover damages. We can say damages. Damages. But actually, under criminal law, there is no benefit given to that investor, right? Only thing is, under criminal law, the company or any person who authorized the publication of such prospectus contain an untrue statement, right, shall be guilty to an offense, right? On conviction, be liable to pay fine uh, and imprisonment. Imprisonment, fine and or imprisonment, right? So fine fine, it is given to the state, not to the investor. It is not damages, fine, right? The fine is predetermined, right? So we can identify the fine is 500,000 rupees. And the imprisonment is for a term not exceeding 2 years. It is predetermined, right? That is not the loss maybe happened to that investor. Another thing is this fine is given to the state. It is given to the state, not to the aggrieved party, not to the innocent party, or not to the person who has invested in the company, right? Therefore, actually, under criminal law, only thing is fine. The court can impose a fine and give imprisonment to the person who has authorized the issue of such prospectus contain an untrue statement. Understood? So basically, there are two remedies or the reliefs available, or the right. There are two outcomes we can identify if there is an untrue statement in the prospectus. One is under civil law, right? Then under civil law, that investor can recover damages from the company and officers who made untrue statement in the prospectus, right? So under civil law, the benefit is given to the investor. But under criminal law, only punishment is given, right? There is no any benefit to the investor, but the court can impose a fine, right, not exceeding 500,000 rupees, and the fine is given to the state. That the person or the company has to pay fine to the state, and another punishment can be given here, that is imprisonment, right? For a term not exceeding 2 years. Imprisonment for a term not exceeding 2 years. That's the punishment can be given, right? Is it clear to you? Right. Only thing is under civil law can claim damages. He can recover the damages. So the person who has invested in the company rely on the untrue statement, then if he suffers any loss, then he can recover it. That is the loss or damage he can recover, right? So under criminal law, can impose fine and imprisonment for the imprisonment to the wrongdoer, right? Person who has authorized the publication of prospectus contain untrue statement, right? Then, right, by that way, actually, court can prevent that company or the persons who are making an untrue statement in the prospectus in the future, right? It is not actually directly affected to the investor, right? So by these provisions under criminal law, the court can prevent some other transactions maybe happen in the future because of the punishment, right? So that will happen under the criminal law, right? So we can consider, right, under the Companies Act, there are two remedies, reliefs, remedies available to the innocent party who purchase shares of a company on the ground of untrue statement in the prospectus. The first one is civil liability, right? Any person who suffers any loss or damage as a result of any untrue statement in the prospectus that person is entitled to recover damages from the following persons, right? So, entitled to recover damages from whom? Every person who is a director of the company at the time of issue of the prospectus, from directors, right? And every person who is named in the prospectus as a director, right? Who name in the prospectus. Now, some directors are not named in the prospectus, but under first category, that person can recover because director of the company at the time of issue of the prospectus, and from the directors whose names mentioned in the prospectus, and every person who is being a promoter, right? We have discussed the person who is taking necessary steps in order to incorporate a company with a view of with an intention to incorporate a company under the Companies Act. He is a person who is taking necessary steps uh, with an intention to incorporate a company under the Companies Act. Right, and every person who has authorized the issue of prospectus, authorized the issue, right, and experts. Right, sometimes expertise may be involved with the prospectus. Then if there is an untrue statement, then aggrieved party can claim damages from that experts who have made untrue statement in the prospectus. That is under civil law. Only thing is the damages can be uh, recovered from the company, right? The person who has suffered any loss, he can recover the damages. That will happen under the civil law, or it is known as civil liability, right? So actually, the liability is to the company or these persons who made that untrue statement in the prospectus, right? Then criminal liability. Every person who authorized the issue of prospectus contain an untrue statement shall be guilty to an offense. On conviction, be liable to pay a fine not exceeding 500,000 rupees. Right? Again, here, not exceeding. Now, here, if it says a fine minimum of 500,000 rupees, the minimum amount can be charge is 500,000 rupees. But here, not exceeding. Not exceeding means even 1,000 rupees is valid. That is within law. Not exceeding, right? If it cannot exceed 500,000 rupees. If it is less than any amount less than 500,000 rupees can be imposed, right? Or imprisonment for a term not exceeding. Again, not exceeding 2 years, right? The maximum can be given 2 years. So 6 months, it is permitted, right? Because it is not exceeding 2 years. So 1 month, 2 months, 6 months uh, can be given. It is permitted or it is valid according to the provisions, right? So here it says not exceeding 2 years. In some offences, minimum fine, minimum imprisonment may be mentioned. Now, for an example, we can say uh, to pay liable to pay a fine minimum of 500,000 rupees, right? Minimum of 5,000 rupees. The minimum amount can be charged is 500,000 rupees, or an imprisonment for a term minimum of 2 years. If it says minimum of 2 years, then minimally uh, he has to punish by imprisonment for a term 2 years, right? It cannot be less than 2 years, minimum punishments given. But here not exceeding. Not exceeding means cannot exceed that amount. So below that amount, any range, right? In that any range, any fine or any uh, period of time can be given. right? So that is under criminal liability, right? Fine is given to the state, it is not to the investor, and there is no benefit under the criminal law. Only thing is court will or the law will consider, because of this criminal liability, it can prevent the companies from engaging into this type of transactions in the future, right? So with that aspect, criminal liability is imposed with regard to these prospectus contain untrue statement, right? That is about the prospectus. Is it clear?
Yes, sir.
Okay,
Yes, sir.
right. Then thereafter, we can consider the
Excuse me, sir.
yes,
This in invitation section, what is the meaning of
yeah.
mirror request?
Mere means just request. Mere request to start negotiations. Just right request to start negotiations. Mere means just නිකං කියන තේරුම. උදෙක්. මිය කියන්නේ නිකං කරන ඉල්ලීම. Mere request. නිකං. Right? Is it clear?
Yes, sir. Thank you.
Mere request means නිකං just request. It's just request. Right? නිකං ඉල්ලීමක් කරනවා කියන එක තමයි ඒකේ තේරුම. නිකං. Right? Just. So mere request. Right. Then our next topic is capital. Now, by way of prospectus, right, the company can raise its capital, right, because shares and debentures can be issued to the public right now. Then thereafter, we can we can discuss about the capital under this topic, capital. So basically, we can classify the capital into two, right? Earlier also we have mentioned this. That is share capital and loan capital. When we consider the debentures, right? Debentures, they are loan capital, right? When we consider the share capital, we can further classify the share capital as ordinary shares and preference shares, right? So likewise, we can classify the capital of the company, right? Share capital and loan capital. Share capital, we can further classify it as ordinary shares and preference shares, right? I think this is well known to you, right? That is, capital is the funds available for the use in the business of the company. Actually, capital means funds, right? The company's capital may consist of share capital, loan capital, or loan capital means debenture capital, right? Debentures, right? When we consider the share capital, right? Then share capital. First, we have to consider about the nature of share capital, right? Nature of share capital. So we can identify some features or characteristics of a share capital, right? That is, it is share capital or shares are movable property, and share has no nominal or par value, no nominal value or par value, right? And further it says they are transferable, able to transfer. The transferable means able to transfer the ownership of the shares to another person. Transferable, right? Movables, no nominal value or par value. It is transferable, right? You can transfer the ownership of the shares to another person. Transferring of ownership. Or in simple terms, we can say sell. You can sell shares to another person. That is transfer the ownership, transferable in a manner provided in the article. So according to the provisions contained in the articles, shares can be transferred to another person, right? A share in a company shall confer on the holder. Confer means gives, right? A share in the company shall give on the holder, right? It will or it shall give on the holder these rights, right? What are the rights? There are several rights recognized here. The first thing is right to one vote, right to one vote on a poll, right? Now at the meetings, right, in the topic of meeting, we have discussed there are two methods of voting. One is uh, on a poll or by show of hands, right? If it is a poll, then every shareholder is entitled to cast one vote per share. One vote per share. If it is a show of hands, right, then every shareholder has one vote, right? One vote. But on a poll, one vote per share. So here it says the right to one vote on a poll at a meeting on any resolution, right? So actually voting right is given at a meeting, right? So we can say general meeting, shareholders meeting, right? In order to make a decision. Resolution means resolution, right? Decision. Then thereafter another right is an equal share in dividends paid by the company. Equal share in dividends. If the company uh, if the company pays or decided to pay dividends to the shareholders, then shareholder has a right to an equal share in dividends, right, paid by the company, and right to an equal share in uh, distribution of surplus assets. Another right given to the shareholder, that is an equal share in distribution of surplus assets, right? Distribution of surplus assets. Now here the new word here, surplus assets. Now surplus assets means, now here further it says surplus assets of the company in the event of liquidation, right? Right. In the event of liquidation, actually what happened now? Liquidation means, right? Right after winding up of the company, or it is known as liquidation. So after liquidation, the existence of the company is ceased, right? Then thereafter no company available after the liquidation or winding up. It is known as winding up. Now in the winding up process, actually, right, these are the steps. First, company has to collect all the assets of the company, collect the assets and sell them, or we can say realize them. Then out of the that money, right, from uh, realizing the assets of the company, then company has to pay the creditors, right? Company has to pay the creditors and the winding up expenses. Then after paying the creditors and winding up expenses, right? If any amount remain in the company, right? In any money amount remain in the company, That remaining amount is known as surplus assets. Understood? That is known as surplus assets. Right? Then what happened? Now, creditors are already paid off, right? Creditors paid off and the expenses are paid off. After settling creditors and expenses, winding up expenses, any money amount remain in the company, that amount is known as surplus assets. It to be distributed among the shareholders. Right? So here it says a right to an equal share in distribution of surplus assets in the event of liquidation. Right? So in the event, in the winding up process, the company has to collect the assets, sell them, and out of that money, company has to settle the creditors and expenses. After settling the creditors and expenses, if any money amount remain in the company, that is known as surplus assets. It to be distributed among the shareholders. So here, shareholder has a right to an equal share in distribution of surplus assets in the event of liquidation. Understood? Is it clear?
Yes, sir.
Okay.
Yes, sir.
Then another right is rights which are approved by the board of directors at the time of issuing of shares uh, as terms of issue. Now, in the prospectus also we have discussed this, right? Terms of issue. These are the rights, right? Approved by the board of directors at the time of issuing of shares. At the time of issuing of shares, right? So these are the right some types of rights given to the shareholders, right, at the time of issuing of shares. So these are the rights that we can identify with regard to the shareholders. One vote on a poll, an equal share in dividends, right, and equal share in distribution of surplus assets in the event of liquidation. Rights which are approved by the board of directors at the time of issuing of shares. So these rights given to the shareholders, right? Then these are the nature, uh, these are the features of shares, right? They are movables, no nominal or par value, transferable, able to transfer the ownership, right, according to the provisions contained in the articles, and some rights shall give uh, to the shareholders, right? So these are the rights given to the shareholders. Then the share capital of the company may consist of, now we are going to consider about the share capital. Right now here also we have mentioned share capital. We can further classified as ordinary shares and preference shares. Ordinary shares, so we can name them as equity shares. Equity shares, right? Or we can say ordinary shares, right? Ordinary shares. Ordinary shares or equity shares or equity capital. Here it says capital, right? Or equity capital or equity shares, right? Or ordinary shares, right? Actually, who are equity shareholders or ordinary shareholders, right? Equity shareholders or the ordinary shareholders, they are the real owners of the company, right? They are the real owners, right, of the company, right? They will enjoy, right, residential profits after settling the uh, creditors and preference shareholders, right? Now, because of the real owners of the company, right now, suppose the company has uh, uh, gained a profit. Then out of that profit, right, first company has to pay for the creditors or debenture holders. Company has to pay the interest for the debentures. Then thereafter, right, company has to pay the uh, preference shareholders, right? Then after paying the preference shareholders and creditors, if any amount remain in the company, right, then uh, it can be, right, given to the ordinary shareholders, right? So that is why, by being a real owners of the company, first the priority is given for the preference shareholders and creditors, and thereafter the preference is given to the ordinary shareholders or equity shareholders, right? Equity shareholders or ordinary shareholders are the owners of the company, or we can say real owners of the company. They enjoy the residential profits of the company after having paid the creditors like debentures, right, and preference shareholders, right. So first, right, the choice to be given to the creditors and preference shareholders. Then after settling the creditors and preference shareholders, then real owners or the owners or the equity shareholders uh, can receive uh, money or the profit, right, or dividends, right, whatever, right. That benefit can be given to the ordinary shareholders, right, after paying the creditors and preference shareholders, right. Then capital, preference share capital, preference shareholders. Now here, preference, the meaning is preference, the word is preference. Preference shareholders have the preference over the equity shareholders. Now they have the preference over the equity shareholders or ordinary shareholders for what? Receiving dividends and being paid off the capital in the event of liquidation. That's why we name them as preference shareholders. Right? It means the first priority to be given to preference shareholders, right? Uh, for paying dividends. Right? So here also we have mentioned that real shareholders, real owners of the company, not shareholders, right? Real owners of the company or ordinary shareholders shall enjoy residential profits after paying the preference shareholder. So first priority to be given to the preference shareholder. And thereafter, uh, the ordinary shareholders, right? Profits to be distributed to the ordinary shareholders, right? So here preference is given on two things. One is for receiving dividends, and being paid off the capital in the event of liquidation. So in the event of liquidation also, now I told you, first we have to pay for the, out of that money, we have to settle the creditors, right, and expenses, right. So under creditors, actually, uh, we can uh, we can identify debenture holders under that creditors, right, debentures and expenses. Then thereafter, right, then we have to settle the preference shareholders. Then if any amount remain in the company, it to be distributed among the shareholders. Actually, here shareholders means ordinary shareholders, right? So they have the preference over the equity shareholders for receiving dividends as well as being paid off the capital in the event of liquidation, right? So that's why we name them as preference shareholders, right? Then types of preference shareholders, right? Cumulative and non-cumulative. Cumulative means, right, these shareholders are entitled to receive dividends on cumulative basis. That is, in a particular year, financial year, if the company unable to pay, unable to pay dividends because of no profit or lack of profit, then what happened? Before declaring the dividends to equity shareholders, the company has to pay arrears of dividends to these shareholders. Or these shareholders, these preference shareholders are entitled to receive dividends on cumulative basis. They are entitled to receive arrears amount of dividends, right? Then company has to pay the arrears before paying the equity shareholders, right? So that is known as cumulative and non-cumulative. Non-cumulative means these preference shareholders uh, don't have that right, right? In a particular year, if the company unable to pay dividends, then next year they unable to receive that, right? Not because it is not non-cumulative. Arrears cannot be recovered in on next or in next year. That is non-cumulative, right? Non-cumulative preference shares, right? Cumulative shareholders are entitled to the dividends on cumulative basis. Cumulative basis, right? It means in any financial year, if these shareholders are not being paid due to insufficient profits, the company will have to pay the arrears of dividends before declaring equity dividends. So company has to pay arrears of dividends to these shareholders before paying the equity shareholders. Non-cumulative, they don't have such right. Non-cumulative, don't have such right, right? So preference shareholders we can divide, consider under two categories: cumulative, non-cumulative. Another category is redeemable and irredeemable preference shares. Redeemable shares means able to redeem, right? That is, right, at the maturity, right, after specific period of time, right, company can buy these shares. That is known as redeemable. Irredeemable means unable to purchase the shares, right? Unable to purchase these shares, right? It means these irredeemable shares remain in the company until the winding up of the company, right? Same as ordinary shares, right? Ordinary shares also, right, remain with the company until the winding up of the company, right? So same as here, these preference shares, if they are irredeemable, or another name is given to that, that is known as perpetual. Perpetual preference shares, right? They can remain in the company until the winding up, until the winding up. So therefore, it is known as irredeemable. Redeemable shares will be redeemed after maturity. Redeem means buy back. Right? Company purchase the shares after the maturity. But perpetual shares will remain with the company forever. Right? That is until the winding up. Right? They will remain in the company forever. Same as equity shares. Same as real owners of the company. Right. Then another type is, another category, convertible and non-convertible. Convertible means these preference shareholders can be converted into equity shares at the maturity, right? Non-convertible means unable to convert into equity shares, right? If it is permitted by articles, convertible shares can be converted to equity shares in the future date, right? In the future, these shares can be converted into equity shares. Non-convertible shares cannot be converted into equity shares. So that is very simple that we can, by considering these meaning of words, we can identify. Convertible means converted into equity. Non-convertible means unable to convert into equity shares. Redeemable shares means company can buy back at the maturity. Irredeemable means unable to buy back but remain in the company until the winding up, as same as ordinary shares. Cumulative means they are entitled to receive dividends on cumulative basis. If a particular year a company unable to pay dividends, then next year, right, they can these shareholders can receive the arrears of dividends, right? Not if the company is not declare dividends, then right, then next year they cannot ask the arrears of dividends because non-cumulative preference shares, right? Then thereafter it says notice to the registrar regarding issue of shares, right? Now the company issue shares, then what happened? The share capital, the amount of share capital will increase, right? That amount will increase. Then, according to section 21 of the Companies Act, it says within 20 working days of the issue of any share, the company shall give notice to the registrar by way of Form 6 by specifying number of shares issued, amount of consideration of the shares issued, the value, consideration means value, and the amount of stated capital following the share issue. Following the share issue means the stated capital after the share issue. What is the stated capital after the share issue? And a copy of the terms of issue. Terms of issue means these are the rights approved by the board of directors at the time of issue of these shares. The copy of that to be given to the register along with this Form 6, right? So that is a requirement after issuing of shares, right? Then there's another heading, it says preemptive right. Now we have discussed actually preemptive right, that is under Articles of Association. Preemptive right means very simple thing, that is A has a right over the property of B, right? A particular right is given to A over the property of B. Then if A has a preemptive right over the property of B, then what happens if B wants to sell the property, right? If B wants to sell his property, then what happens? The first choice to purchase the property to be given to A, because A has a preemptive right. A has a right. We can identify that concept like this, right? A has a right. A has a right over the property of B. Understood? A has a right over the property of B. Therefore, what happened? B is the owner of a property. Now, suppose B is the owner of a land, right? B is a owner of a land, owner owner of a land. But only thing is, A has a right over the property of B. B is the owner, but there's a right given to another party called A, right? So that right is known as preemptive right, right? So if there is a preemptive right, if A has a preemptive right over the property of B, right? B cannot straight away sell this land to another person, right? We cannot straight away sell this land to another person, right? First, we must ask A to purchase the land, right? Because A has a preemptive right. Therefore, the first choice to purchase the land to be given to A. If A refuses to purchase the land, right, only then B can sell it to outside party, right, or third party, ouster, right? B can sell it to C. Only A refused to purchase the land. So this is the particular right given to a person, right, over the property of B, right? So same right. So this is the preemptive right. So this preemptive right is recognized by the Companies Act under Section 53. Right here, it's actually what happened. Now the company is going to issue shares, right? Issue shares which are of equal or above voting and distribution rights, right? Now suppose we can consider one part. The company is going to issue shares uh, which has equal voting right, right? Voting right when we comparing with the existing shareholders, right? The company is going to issue shares, right? When we comparing these shares with the existing shareholders, right? These shares has equal or above voting rights, right? Equal or above voting rights when comparing with the existing shareholders. Understood, right? Now, company not yet issue shares, right? Going to issue shares, right? These shares have equal or above voting right when comparing with the uh, shares owned by the existing shareholders. Then what happens? Section 53 of the Companies Act says, right? Uh, the company shall give first choice to the existing shareholders to purchase these shares, right? If these shareholders refuse to purchase the shares, then the company can issue them to third party, right? Why? Reason is now in order to, right, control the affairs of the company, right? Because now uh, if the company issue these shares to third party, then newcomers uh, will come to the company. Then it may be affected to the management and voting right of the existing shareholders of the company. So therefore, in order to regulate the voting and distribution right of the or the rights of the existing shareholders and the management of the company, right? In order to manage that properly, the Companies Act says the company must give the first choice to the existing shareholders to purchase these shares. If they are not purchased, right? If they are not purchasing these shares, then company can sell them to third party. Again, the same concept known as preemptive right, right? Preemptive right. So here it says subject to the provisions contained in the articles where a company is going to issue shares. It is not yet issued, right? Going to issue. right? This will happen in the future, right? Going to issue shares which are of equal or above voting and distribution right. Equal or above. Equal or above voting and distribution right. Distribution rights when comparing with the existing shareholders. So actually we have to compare voting and distribution right with the existing shareholders. Then these shares has equal or above voting and distribution rights. Then those shares shall be offered to the existing shareholders. The first choice to be given to whom? Existing shareholders, in order to maintain the relative voting and distribution right of the existing shareholders. Right? So in order to regulate the voting and distribution rights of the existing shareholders, the first choice to be given to the existing shareholders. That is the preemptive right. So the only thing is existing shareholders are entitled to purchase these shares because they have preemptive right over the shares of the company. Shares of the company. It is recognized under Section 53 of the Companies Act. Understood? Is it clear?
Yes, sir.
Okay. Then, so this is about the share capital. Now, share capital, ordinary shares or equity shares, then preference shares we have discussed. Preference shares classified right, into several categories, right? Then there are, we can move on to the loan capital. It's about the debentures, right? Debenture, when we consider the debenture, it's a written document issued by a company acknowledging to pay a specific rate of interest, right? Like 10%, 12%, specific rate of interest for a specified period, like 1 year, 2 year, right? Specific period, right? So this is the written document issued by the company acknowledging to pay a specific rate of interest, right? For a specified period and pay the invested amount that is known as capital amount at the maturity, right? Interest and amount finance for the right interest and the amount deposit, right? This document, right, is an acknowledgement with regard to the interest as well as the amount invested, right, in the company, right? So here, according to the document, right, company, right, acknowledge that the specific rate of interest will be paid for a specified period and pay the amount invested, it is known as principal amount at the maturity. So this document is known as debenture. Debenture interest to be paid whether the company makes profits or not. Profits or not. Right? Whether the company makes profit or not, company shall pay interest for the debentures, right? That is not like a dividends. Now, if it is a dividend payment, then only company makes profit, company can pay dividends. But here, no option, whether profit or not, right? The company has to pay for the debenture holders, right? So that is the compulsory requirement. It's like a loan, right? It's a loan taken by the company, borrowing money from a creditor, right? Specific rate mentioned, that rate of interest to be paid for the specified period. And after maturity, the invested amount to be paid. That is the debenture, right? Then types of debentures, we can identify there are two types. There are several categories. Under the first category, it says redeemable and irredeemable. Now here actually redeemable means now generally we are mentioning as redeemable uh, for buyback. Right, company can buy back the now under shares, preference shares. We have discussed redeemable and irredeemable preference shares. Redeemable means company can buy back these shares. Irredeemable means, or perpetual shares means, unable to repurchase. They will remain in the company until winding. But here the redeemable and irredeemable, that meaning is not like that. Right? Meaning is redeemable means, right? These are the debentures, right? They are taken for short-term loans, right? Or we can say they are issued against short-term loans, right? Irredeemable debentures mean that these are issued against long-term loans, right? Long-term loans. Or whether it is short-term or long-term, right? Depend on that, we classified the debentures as redeemable and irredeemable. Redeemable means short-term debentures. So the debentures issued against short-term loans. Irredeemable means debentures issued against long-term loans. That is the meaning here, right? So redeemable debentures are short-term debentures normally repayable at a particular date. Irredeemable debenture is issued against long-term loans, repayable after a long period or on winding up of the company. So generally, on winding up of the company has to settle these irredeemable debentures. Irredeemable debentures. Long-term loans. Right. Convertible and non-convertible. Convertible means it has the same meaning as the shares. Debenture. Now here we are discussing about debenture. Convertible debenture means at the maturity, that debenture holder has an option that he can convert the amount, total of all amounts, into equity shares. Non-convertible means that option is not given to the debenture holders, right? Convertible debenture holders has an option to either recover in the loan with the interest, right? He can recover the loan as well as the interest, or get in his loan, converting into equity shares, right? That amount can be converted into equity shares after maturity. Non-convertible holders have no such right. That is the meaning of convertible and non-convertible. Convertible means converted into equity shares. Non-convertible means unable to convert into equity shares. Right? So at the maturity, the debenture holder can convert his loan and the interest into equity shares. That is known as convertible. Right? Convertible and non-convertible. Then thereafter, it says differences between shareholder and debenture holder. You can go through this, right? Very simple, right? Shareholders are entitled to cast votes at general meeting, right? They are entitled to cast votes at general meeting, but debenture holders have no such right, right? Then shareholders enjoy residential profit after paying debentures. So here, debenture holders, right, have the preference, right, over the shares, right, over the equity shares or the preference shares, right. First, we have to pay for the debentures because they are the creditors. Then they are the priority to be given to the debenture holders, right? Interest for the debentures. Then thereafter preference shareholders. Then thereafter equity shareholders. So, right? First choice to be given to the debenture holders. Second choice to be given to the preference shareholders. And the third and the last one, the preference to be given to the equity shareholders or ordinary shareholders, right? So that is the way how we have to settle the right. Then there's another one here. It says shareholders represents equity share capital, right? And debenture holders they represents loan capital, equity capital or share capital and loan capital, right? The category that we have mentioned, right? Debenture interest to be paid whether the company makes profits or not, but only if the company makes profits, dividends will be paid to the shareholders. Debenture holders receive a specific rate. That amount is fixed rate, right? Specific rate of interest for a specific period, but shareholders' amount of dividend is not certain, right? It is yearly. It will change, right? The amount to be amount of dividend is not certain, right? So these are the differences we can identify, right? Then thereafter, advantages and disadvantages of raising loan capital. You can go through these, right? Loan capital and share capital are two types of borrowing money by a company. Types of borrowing loans, borrowing by loan capital are debentures, mortgage of corporate assets, known as secured loans, and unsecured loans, overdraft, and bills of exchange. So these are examples. Advantages mentioned here, right? And disadvantages also mentioned here. Like you can go through them, right? All facts, right? Then we can consider another important area, that is stated capital. Like one topic we have to consider stated capital. Then thereafter solvency test, right? Solvency test and types of distribution, another right topic, types of distribution, and thereafter reduction of stated capital, right? Repurchase and redemption. Like there are three things we have to consider here, right? Right. Right. So first we have to consider about the stated capital. Stated capital means the total of all amounts received by the company, right? So here it says total of all amounts received by the company in respect of issue of shares. Now, after issuing shares, right, shareholders, right, pay money to the company. So that amount. And now calls on shares, right? So company can ask the shareholders to pay money, right? First call, second call, likewise, there are several calls we can identify. Then the money may be paid to the company on calls, right? Then all together, we can say this total of all amounts is treated as the stated capital, right? The total of all amounts received by the company by issuing of shares and calls on shares. Altogether, we name it as share capital. Then there's a test, solvency test, right? We have discussed these solvency test. Now, yes, one occasion that we have discussed this under types of companies. If it is a private company, we have discussed private company can by way of a unanimous agreement, private company can take any decision, even though that decision is against the articles of association, right? By unanimous agreement. Unanimous agreement means an agreement in writing signed by all the shareholders. That is the meaning unanimous. Unanimous agreement. Agreement in writing signed by all the shareholders. Private company can take any decision even though it is contradicted with the provisions contained in the articles, but subject to one condition, that is, company must be able to meet the solvency test, right? So here also we are going to discuss about the same test. It's a particular test. We have to, if the company, that private company, able to meet the solvency test, then that company can take any decision by unanimous agreement, even though it is not comply with the provisions contained in the articles. Right? What is the test? Right? So here we have to check two things. The first one is two conditions. If a company able to meet these two conditions, then we can say the company able to meet the solvency test. The first one is very simple. We have to check whether the company is able to pay its debts in its ordinary course of business. Able to pay, whether the company able to pay its debts in its ordinary course of business. And the second thing is, we have to check whether the company has reserves. So here actually the company's access, whether the value of the assets of the company is greater than liabilities and stated capital. That is very simple to identify like this. Now, when we consider the assets equal to stated capital plus liabilities and reserves. Right. So here, second condition is we have to check whether the assets, the value of the assets is greater than or more than stated capital plus liabilities, right? Then stated capital plus liabilities, the remaining portion is reserves. Then we have to check whether reserves are available in the company, right? So two things we have to consider, whether the company able to pay its debts in its ordinary course of business and whether the company has reserves. Then company able to meet the solvency test, right? Then we can move on to the last heading here. It says we have to use solvency test in order to perform these activities, right? The company must satisfy the solvency test to perform following activities. So one activity that we have discussed under the private companies, right, under unanimous agreement, right. Apart from that, these are some other activities that the company must able to satisfy uh, in order to perform these activities, company must satisfy solvency test, right. The first one is reduction of stated capital, payment of dividend, right. So in order to pay payment of dividends, then company must able to satisfy the solvency test. Repurchase of company shares, repurchase, another word, repurchase. I'll come to that later, right? Reduction, another word, reduction here, repurchase, redemption of shares, another one, right? Repurchase, reduction, repurchase, redemption, right? So these are some activities, right? Right. Then, yes, we can consider this is the solvency test. Then thereafter, next heading it says distribution, types of distribution. Distribution, right? Here actually now, suppose the company uh, earns profit, then uh, the company can utilize this profit on three options, right? The first one is out of that profit, company can remain some amount with the company. That is known as reserves, or making reserves out of that profit, right? So first uh, option is company can retain it with the company. It is known as reserves. And the second option is company can pay dividends to the shareholders, pay dividends. And another one is company can repurchase of shares or redeem the shares. Redeem the shares. Repurchase or redeem. Right? Repurchase, redeem. Two things. Two concepts. Redemption, repurchase. Repurchase means buyback. Buyback its shares. Or redeem the shares. Redeem the shares. Now, we have discussed redeemable shares, redeemable and irredeemable shares, right? Redeemable preference shares, irredeemable preference shares. Redeemable preference shares means company can buy back these shares, right? Irredeemable preference shares means company unable to redeem these, right? Right? Company unable to redeem them, irredeemable. Right. Another word here mentioned as repurchase. We consider what is repurchase, right? So company, if the company gain a profit, company gains a profit, then that profit can be utilized on three options. Company can retain as reserves and pay dividends to shareholders, or repurchase or redeem the shares of the company. Repurchase or redeem. Right. Then thereafter it says distribution. Distribution means that is actually outflow. Now making reserves, then the money is not go out, right? This is not outflow, right? But payment of dividends, what happened to the money? It goes out. Repurchase, redeem, goes out. Money goes out, Right. So here distribution means, right, transfer of money or property. Right. Transfer of money of property other than shares of the company to the shareholders. Now here transfer of money or property to the shareholders. That is known as distribution. But issuing shares of the company to the shareholders of the company, it is not treated as distribution. Other than shares of the company, like transfer of shares of the company to shareholders of the company. Right? This is known as right issue. Company can now, instead of payment of dividends, company can issue its shares to the shareholders, right? But it is not treated as distribution of money or property, because the company shares issued to the, right, shareholders of the company, same company, right? Right issue, it is known as right issue, right? So the company, its own shares issued to the shareholders of the company, right? It is not distribution, right? But transfer of money or property, right, excluding this one, to the shareholders, known as distribution. That is the distribution of profits, right, or the money or property of the company to outside. Distribute the money to outside, right? It means actually when we consider these three options, right, making reserves, it is not a distribution. Payment of dividends, right, repurchase or redemption of shares. Repurchase of shares, redemption of shares, right, payment of dividends. They are known as distribution. Here it says incurring of a debt to or for the benefit of the shareholder in relation to shares held by a shareholder by means of payment of dividend, redemption, or acquisition. Acquisition means repurchase of shares. This is known as distribution. Distribution of profits. Distribution of profit means transfer of money or property, except shares of the company to shareholders. Right? Transfer of money or property, right? That is transferring the money or property to the shareholders by way of payment of dividend, redemption, or repurchase of shares. Understood? Right? That is known as distribution. Distribution means outflow. Inflow, outflow, right? So outflow means money or property goes out. Money goes out, right? It goes to the shareholders, right? But if it is a right issue, right? Issuing company issue, uh, companies issue, company issue shares to the shareholders, own shares to the shareholders, then that is not an outflow, right? So apart from that, transfer money or property to the shareholder, that is known as distribution. It means payment of dividends to the shareholders, redeemable shares, or acquisition of the shares. Then what happens? Money goes out, right? That is known as distribution. Distribution. Then dividend means distribution. It's a particular kind of distribution out of profits of the company other than now under distribution we can identify three things. payment of dividend, redemption, and acquisition. So dividend means, right? Dividend payment of dividend means distribution of profits other than redemption or acquisition, right? So that is the way how Companies Act define the payment of dividend. A dividend is a distribution out of profits of the company other than acquisition of its own shares or redemption of shares. So other than these last two, distribution of profits is known as payment of dividend. Payment of dividend. Understood? Right? Now, solvency test, stated capital, that is the total of all amounts received by the company by issuing of shares and calls on shares, and solvency test. And distribution means money goes out, right? That is transferring of money or property other than issuing shares to the shareholders, right? Or we can say payment of dividend, right? Or redemption or acquisition of shares, right? So that is known as distribution, goes out, right? Then we can identify what is the dividend, right? Payment of dividend, that is distribution of profits of the company other than acquisition or redemption of shares. Then thereafter, there are three things we have to consider here, like basically two things: redemption and acquisition. Redemption and acquisition. Then there's another concept included to that, that is known as reduction of stated capital. Reduction of stated capital, right? Then acquisition, or we can say repurchase, and redemption. Redemption. So altogether there are three concepts, right? Reduction of stated capital, repurchase, redemption, right? First, we can start from redemption. Here, redemption means, now when we consider the share capital, there are two types of shares: ordinary shares and preference shares, right? Preference shares, ordinary shares and preference shares. And under preference shares, we can identify another two types, that is redeemable shares and irredeemable shares, right? When we consider the redeemable shares, right? So here, ordinary shares, preference shares. Simple chart mentioned here, right? Ordinary shares, actually, it to be shares divided into two, right? We have to unable to take that, right? Shares to be here. Yes. All right. Right, shares we can divide into two: ordinary shares and preference shares. Preference shares we can divide into two: redeemable and irredeemable. Right. Now we are going to redeem the shares. Actually, we can redeem the shares by three ways, right? At the option of the company. So here the company decided to, right, redeem the redeemable shares. This is known as at the option of the company. Here the board must pass a resolution stating that the redemption is in the interest of the company, right? For the interest of the company, they are going to redeem the shares at the option of the company. Then the second way is at the option of the holders of shares. So these redeemable shareholders request the company to purchase their shares. That is under second option, right? At the option of the holders of which. Here the shareholders must give notice requiring the company, requesting the company to redeem the shares. So they are requesting company to redeem the share. Then redemption will be take place on the date mentioned in the notice, or if no date mentioned on the date of receipt of the notice. So once the receipt of the notice, it can be redeemed, or on the date mentioned in the requisition, the company can redeem the shares. That is on the option of the holders of shares. And the third one is on the date specified in the articles. Here actually what happened, the article says these shares to be redeemed on this particular date. Then on that date, company can redeem the shares. So we can identify by three ways company can redeem shares. Right? On the option of the company, on the option of the holders of which, on the date specified in the articles. Right? Three options we can identify. Then this one, first one, right? On the option of the company. On the option of the company. Right. It is highlighted in green color because of a special reason. Right. Then we can consider the repurchase. Repurchase of shares. Second thing. Now, three things we are going to discuss. Redemption, repurchase, and reduction. Right. Repurchase. Repurchase means, right? Section 67. That is redemption of redeemable shares at the option of the company. That is what I have highlighted in green, yes, yellow color here, right? At the option of the company, section 67, right? So here the same redemption of redeemable shares at the option of the company. So redeemable shares can be redeemed by three ways: at the option of the company, at the option of the holders of shares, and on the date specified in the articles. So this is the first one, right? At the option of the company. And now when we consider the classification, we can identify, right? Now this is redeemable shares. Now already we have discussed about that. Ordinary shares. Apart from this one, we can identify other two types of shares. Ordinary shares and irredeemable shares. Right. Now, ordinary shares or irredeemable shares, company can repurchase. Right. These two, which are highlighted in green color. Right. Ordinary shares or irredeemable shares. Now, irredeemable shares means company cannot redeem. They will remain in the company until the winding down. Right? And the classification we have discussed. But for the interest of the company, according to the Companies Act, actually the company can repurchase its ordinary shares as well as the irredeemable shares. Right? We'll take these two into here. Right? Repurchase of irredeemable or ordinary shares. Understood? Irredeemable or ordinary shares. Both of these are known as repurchase. Understood? repurchase. These two are known as repurchase. Repurchase of shares means repurchase of ordinary shares or irredeemable shares. And redemption of redeemable shares on the option of the company. Right? These, or we can say section 64 or section 67. Both of these sections, right, known as repurchase. Repurchase. Understood? That is the repurchase. Right? Then now we have discussed redemption, then repurchase. Then the third concept is known as reduction. Reduction. Reduction means, right, if there is a repurchase, right, repurchase or redemption of shares at the option of the holders of shares. Redemption of redeemable shares on the date specified on the articles, right? Right? Or repurchase. No, I have taken this, no? Right. We can right, mention like this. Now we are discussing about the reduction. Reduction means, right? Reduction of stated capital means this one. I will number it as 1, right? 1 and this one 2 and this one third one. This is third one. These three, right, are known as reduction, or these three amounts amount to the reduction of stated capital, right? Reduction of stated capital means reduce the stated capital of the company, right? So if it is a repurchase, right, repurchase, so we are here, repurchase, right? So under repurchase, we have recognized redemption of redeemable shares at the option of the company. So apart from this one, another two occasions we identify under redemption. That is at the option of the holders of it on the date mentioned in the articles. Right. So repurchase, right? Repurchase, or right? The redemption at the option of the holders of shares and on the date on the date redemption of redeemable shares on the date mentioned in the articles, right? All these three, right? Repurchase, right? And redemption of redeemable shares on the option of the holders of it on the date specified in the articles. These three amounts to reduction of stated capital, reduce the stated capital. Understood? So that is the right the relationship between these three concepts, right? Redemption, reduction, and redemption, repurchase, and reduction, right? If it is repurchase or redemption at the option of the holders of which, that is number 2, this one, right? And this one, third one, right? These three, right, amounts to reduction of stated capital, reduce the stated capital. Understood? Is it clear to you?
Yes, sir.
Okay, right. So now, if there is a reduction of stated capital, what are the requirements to be fulfilled? How we can reduce the stated capital of the company? So we can consider reduction of stated capital. If there is a reduction, right, according to section 9, the company may reduce the stated capital, right? But if there is a reduction of stated capital, that decision to be taken by passing a special resolution. Special resolution means resolution passed by majority of 75% of votes after giving not less than 15 working days notice. Then the second requirement is if there is a reduction of stated capital, then public notice to be given, right, not less than 60 days before passing the resolution. So at a meeting, now we have discussed this uh, on the meetings, right? At a meeting, AGM or EGM, company can pass a special resolution, shareholders meeting. So before passing the resolution, at least 60 working days, right? Notice, public notice to be given. Understood? This is known as public notice. Right now, there are two types of notices to be given. In order to call a meeting, notice to be given to the shareholders. Right? In order to call a meeting, now we have discussed in order to call an AGM, annual general meeting, not less than 15 working days notice to be given. Notice to be given to whom? With regard in the annual general meeting, shareholders. If it is an EGM, extraordinary general meeting, right, not less than 5 and 10 working days notice to be given in private and public companies. Here also notices to be given to the shareholders, right? But here, if there is a reduction of stated capital, right, notice to be given to the public, right? It to be given to the public. Now we have discussed about this public notice, that is under incorporation. After incorporation, right, within 30 working days after incorporation, the company shall give public notice. I think you can recall that, right? Public notice. Here the public notice is given by specifying the name of the company, company number, and the address of the registered office, right? After incorporation, within 30 working days, public notice to be given. So if there is a reduction of stated capital, the company is going to reduce the stated capital, again public notice to be given, right? Not less than 60 working days public notice to be given before passing the special resolution, right? Same way, company can give the public notice. So earlier also I told you how company can give public notice by publishing an advertisement in a newspaper, daily newspaper in 3 languages, Sinhala, Tamil, and English, right? Publishing an advertisement in a newspaper. So by that way, the company has to give a public notice. Another requirement is, right? So in order to reduce the stated capital, the company has to pass a special resolution and public notice to be given 60 days prior to passing the special resolution at the general meeting. And another requirement is, now suppose the company engage into a contract with a creditor, right? Company and creditor. Company engage into contract with a creditor not to reduce the stated capital of the company by specific amount, right? Company engage into a contract with a creditor not to reduce the stated capital by specific amount, right? Now suppose the company, by violating the provisions contained in the contract, right? By violating the provisions contained in the contract, if a company has reduced the stated capital, then what happened? That reduction of that decision, or that reduction of stated capital, right, is treated as void. It has no any legal effect, right? It is invalid, right? It is void. It is further mentioned in here. Actually, here that provision introduced to the Companies Act in order to give some protection to the creditors, right? So without consent of the creditors, the company cannot reduce the stated capital by agreed amount. Now, here only thing is the company and the creditor engage into a contract not to reduce the stated capital by a specific amount, right? So, in order to actually, the company can reduce it with consent of the creditors. If the creditors give their consent to reduce the stated capital, right, uh, than the agreed amount, right, then it is okay. But without having the consent of the uh, creditors, if company has reduced the stated capital than that they agreed not to reduce, right, that is the violation. If there is a violation of any the violation of the terms of the contract, then that reduction to be treated as invalid. That is another requirement mentioned in the Companies Act. So here it says where the company agreed in writing with the creditor. So this is the contract that the company will not reduce its stated capital below a specific amount without the prior consent of the creditor. So here the agreement is we are not reducing the stated capital without getting your consent. But what happens if the company reduces its stated capital by breaching such agreement? Such reduction will be invalid and of no effect. Yes, it is invalid and no effect. This is to protect the creditors. Right. Then thereafter it says after reduction within 10 working days, the company shall give notice of reduction to the registered company by way of Form 80. So after reduction, company has to give notice to the register of companies by way of Form 8. Right. So that is after reduction. Notice to be given to the register of companies. Right. So only thing is that if there is a reduction of stated capital, then company must pass a special resolution and public notice to be given, right? Not less than 60 working days prior to pass this special resolution, public notice to be given. And if the company engage into contract with a creditor not to reduce the stated capital by a specific amount without getting the consent of the creditor, by violating that term of the contract, if company has reduced the stated capital, it to be treated as void, right? It has no any validity, or it is not enforceable, right? It is void, right? So that is about the reduction of stated capital. So actually reduction means repurchase, so repurchase and redemption of shares on the option of the holders of which this one, and third one on the date specified in the articles. Repurchase means this one, redemption of redeemable shares on the option of the company, that is, and repurchase of ordinary shares and irredeemable shares. Right. So this is the right. Repurchase means this one, and this one, 64 and 67, repurchase. Reduction means repurchase this one and right this one, second one at the option, redemption of redeemable shares at the option of the holders of which, because this first one we have already included to the repurchase. Therefore, we cannot consider this one, right? Second one, that is on the option of the holders of which and on the date specified in the articles. This one. These two are not considered to repurchase. That's why we exclude this one. Already included to here, repurchase. Repurchase, right? Repurchase. To the repurchase, we have included first one. So, under redemption, the second one and third one. These two and repurchase, first one, right, amounts to reduction. So if there is a reduction, it can be done like this, right? So special resolution and public notice, and we have to consider whether there is a contract between shareholder and the creditor. That is about the reduction of stated capital. So here, repurchase is according to which the company may repurchase here we have mentioned, right? Two things. Repurchase, under that it says according to which the company may repurchase its own shares if the articles authorize to do so with approval of the board, right? Here the board must resolve as to the acquisition in the interest of the company. The consideration of the shares is fair value according to the auditors, and the board is unaware of the material non-disclosure to the shareholders with regard to the consideration of the shares. And there is section 64, right? Repurchase of company. The company may repurchase its shares. 64, repurchase of redeemable or ordinary shares. And under 67, right? This is the redemption of redeemable shares at the option of the company, right? Right, so simply we can identify repurchase means 64 or 64 plus 67, these two, right? Repurchase, right? Repurchase and redemption, under redemption, these two, right? These two amounts to a reduction of stated capital, right? Then the company has to comply with section 59 of the Companies Act if there is a reduction of stated capital. Okay. Is it clear?
Yes, sir.
Yes, sir.
Then if there is a, now we can consider now, right, solvency test. If there is a reduction of stated capital, company must meet the solvency test. Repurchase of shares, that is repurchase of ordinary or irredeemable shares, right, must be able to satisfy the solvency test. Redemption of shares. Redemption means, right, redemption means redemption of shares on three options, right? On the option of the company, on the option of the holders of it, on the date specified in the articles. Then company must meet the solvency test. Okay, any question? Yes? Is it clear to you?
Yes, sir.
Okay. Then we can stop for today, right? Okay, thank you very much.